Thank you, Dragana. Good afternoon, everyone. I will start this afternoon session with a very important theme, marriage. The focus is not on epitaphs, but on documentary papyri. I will present three marital contracts, agreements from Roman Egypt, which were composed during the Principate before the Constitutio Antoniniana, which means that different rules applied for different categories of inhabitants. These three agreements, which you have in your handouts, reveal in different ways the practices of three categories. And these are the Romans, those who have had status civitatis, diastoi, which are the Greek-speaking population in the cities, such as Alexandria, Busiris, Oxyrhynchos, etc., and the Egyptians, which were the lowest strata of this mixed society, excluding the slaves here. All of these categories of inhabitants used different languages as well. Eventually, all the documents, even in Roman era, were, or almost all documents, were translated into Greek, since it was the prevailing language of this province. In fact, we have very few marital agreements in Latin. And the one you have is the best preserved. There are only 4 marital agreements written in Latin. It doesn't mean that the Romans didn't draft marital agreements, but we have preserved the Greek translations, and they usually, it is written at the beginning of the document that this is a translation from a Latin contract. So, strictly speaking, drafting a marital agreement was not originally a Roman practice, because Roman law already regulated many of these issues, which are covered in the Greek documents, marital documents. So the Romans did not require such contracts. And the most pressing concern in all of these documents was the property of the wife and the property of the husband. Roman law did not recognize common property between the spouses. Instead, each one of them retained their separate property, with only the right of usufructus of the wife's or the deceased husband's property. This means that the husband can have usufructus of the dowry of the woman while they're married, and after the dissolution of the marriage, he has to return the dowry. But the wife can have usufructus of donatio ante nuptias only after the death of the husband. During their marriage, this was a property managed by the husband. And after the marriage, this was a property that the wife had lifelong usufructus, but she was never the titulary of this property. It belonged to the agnatic family, and in later empire, this is a property that belonged to the children, because the laws has changed and favored the cognatic family instead. So there was no formal marital contract, but the closest equivalents in Latin, in Roman law, were, this was the first I sent you, not the second, but it's all right. Okay, it's all right. So the closest thing they had to marital agreement was dotis dictio and instrumentum dotale. Dotis dictio, this was a verbal contract and a solemn promise of the father of the future bride about the dowry. So with this contract, the interests of the future husband are guaranteed. So, like every other verbal Roman contract, this one was also before 7 witnesses. And you can see that in the papyri. Every Roman document, be it marital agreement, last will, they have 7 witnesses at the end. The same is in the verbal document, in the verbal contracts. So this is the closest thing. And if he didn't give the dowry, there was a lawsuit for the dowry. The next close thing was instrumentum dotale, which was not contract stricto jure. It was more like a dowry inventory that protected the wife. In case of dissolution of the marriage, she knows what belongs to her, because, as I said, they didn't have joint property. They had only a separate property regime. And also Romans didn't have the notary system that the Egyptian population or the Greek-speaking population had and used in Roman Egypt. What we encounter in these papyri written in Greek is syngraphe, which is a written agreement, and this type of agreements were registered at the notary, unlike the Roman documents, which weren't registered at the notary. Of course, they didn't have notary. And afterwards, these syngraphi, if they were agreements about something big, large property, they were additionally registered at the registry office, public registry office. Also, they have this syngraphe trophitidos. The first one, syngraphe is sinoikisias, which was a written agreement for sharing the household between the husband and the wife. But the second one, syngraphe trophitidos, it's something peculiar for the Egyptians. Usually they were written in Demotic and afterwards translated in Greek. This is a written document for maintenance of the wife, which was unusual for the Greek-speaking population. In my own country, in Macedonia, for example, there is no formal marital agreement, marriage agreement, which means there is no alternative matrimonial property regime. Such matters are determined by the statute through a statutory property regime that defines the spouse's assets and governs their division in event of divorce or death. This does not mean that the spouses cannot conclude a marital agreement in Macedonia. They may do so under the law of obligations, provided it aligns with the statutory regime. They may execute such an agreement before a notary if they have specific needs regarding property management during marriage, and they may also terminate the agreement unilaterally, provided the other spouse does not suffer significant financial harm. By contrast, marital agreements from Roman Egypt had the force of law and could not be broken unilaterally, though they left little room for customization. These contracts were highly formulaic, unlike certain modern agreements, especially in the United States, that allow considerable flexibility. Another important distinction is that marriage registration was unknown in Roman law. Even in the time of Justinian, marriages were not registered before state officials or other authorities. As a result, the authorities often lacked reliable knowledge about who married whom, particularly in the provinces. Then what constituted a marriage if they weren't registered? According to Ulpian in Digesta, it was affectio maritalis, and the act of leading the woman into the future husband's home. So this is called uxorem ducere. deductio in domum. And the very fact that she lived in his house and intended to remain there sufficed for a marriage to be recognized. This was the simplest form of marriage, and it was known as usus. The next one is coemptio or coemptio, which was a symbolic purchase via mancipatio. The woman changed her familial status, which was known as capitis diminutio minima. That is changing the familial status from one agnate to other agnate family. The third one was the most ancient and prestigious religious form conducted in the presence of the Pontifex Maximus, in which the bride and the groom shared a piece of fareus panis, which is called confareatio. The agreements that am going to present were not drawn up to register marriage per se, but to register the property and to establish the marital rights and obligations, and they're not exceptions. They're not organized chronologically, but by the category of inhabitants, and I will begin with the Roman contract. This is a marriage contract between Zenarion and Marcus Petronius Servilius. It was written in the 2nd century in Philadelphia. One of the rare documents written in Latin, discovered in Egypt, as I mentioned, one of the 4 Latin marriage contracts. The document is a marriage contract drawn up as a double document, which is unusual for this period. This means that the same text is written in the exterior and the interior, scriptura interior and scriptura exterior. The interior side is sealed and preserved, and the exterior was here for consultation. Both of these sides are heavily damaged in this papyrus. And this is something unusual, double document for this period, because this was something that belonged to the past. For example, the first document, marriage agreement, and at the same time document written in Greek found in Egypt is a double document, the marital contract between Heracles and Demetria, I think, written in 311 BC. This contract concerns a legally valid Roman marriage between Roman citizens, because we can see that the father's name and the groom's name are Roman. They had tria nomina, but not the girl. She is presented here only with her first name, Zenarion, because this was practice in the documents. If the daughter had the same nomen gentilitium as the father, it was not mentioned in the document. The text also refers to Lex Julia de Maritandis Ordinibus, which applied only to Roman citizens. So we are sure that these were Romans. And for those who know what this law covered, it is obvious why this document doesn't have many provisions about the behavior of the husband and the wife, unlike the Greek documents. So this contract, you may observe that resembles a dowry instrument, instrumentum dotale, as it contains a detailed inventory of the dowry brought by the bride, while also mentioning the groom's prenuptial gift. The prenuptial gifts were later introduced in Roman law as obligatory, and they were like counterpart of the dowry. But in this period, this was not something that was obligatory. At the conclusion of the contract, as was customary in Roman agreements, 7 witnesses signed the documents, but their names are written in Greek, which is very interesting because this means that they were Greek-speaking population that were given maybe status civitatis. They weren't Romans. And the scribe employs Latin legal formulas, but the model is clearly the Greek marriage contract. Thus, it is safe to say that these documents represent a hybrid of 2 contract types and 2 languages. We have the instrumentum totale, but registered at the notary, and also reference to the Lex Julia de Maritandis Ordinibus, which was not usual for instrumentum totale. The next marriage contract is between Termion and Apollonius. This is from Alexandria. Although no papyri had been preserved in Alexandria itself, papyri originating from the city have been found elsewhere. For instance, this one was found in Abu el-Melek in Busiris, ancient Busiris. And this contract, dating to the reign of Octavian Augustus, belonged to the archive of certain Protarch, or Protarchos, who was the head of the Alexandrian tribunal from 25 till 5 BC. Legal documents were registered in his office in form of symphoresis agreement, and his archive contains maybe 8 marriage contracts, all of which are written in Greek, and they're not very much different from the ones in the Ptolemaic period. These contracts share a common structure. First, they address Protor, the both contracting parties. Then we have the description of the dowry, then the husband's obligations and the penalties for not fulfillment, which was lacking in the Latin agreement, if you may see. Afterwards, the wife's obligations, and there is a clause stating the couple's intention to conclude an additional syngraphe with official representatives, hierotite, within 5 working days. This part is not preserved in this particular agreement. At the end, there is a request for the contract to be archived, followed by the date. Most Alexandrian contracts do not mention the formal delivery of the bride, ekdosis, and this one as well. However, like many of the Ptolemaic contracts, this one emphasizes that the husband cannot take another wife, so polygamy was forbidden. This is something that was in the Roman statutes. Also, bigamy was a criminal act in Roman law, which was punished with infamia. The husband was forbidden to keep a palake, to have boy lover at home, to have family somewhere else and children with another wife, while the wife was only forbidden to have sexual relations with another man. Sineinai is the verb used for this. Allo andri. For this particular clause, the Romans have the Lex Julia de adulteris coercendis. The third document is a marriage contract between Patinis and Tatres. Patinis is the husband, Tatres is the wife. This is for 42 AD. This is not the actual contract, but the abstract prepared by scribes in the archive, the Grapheion, at Teptinis. And this suggests that the original contract may have been written in Demotic. We don't know that for sure. This contract differs significantly in content from the previous examples, as it is a so-called maintenance contract, as I said at the beginning, singra fetro fitidus, between the husband and the wife. And unlike Greek and Roman agreements, here the husband formally declares that he grants his wife a specified sum of money, together with all property he may later acquire. The woman contributes with a ferna, and consisting of money in this case, along with paraferna, her personal belongings, such as clothing and jewelry. And unlike other marriage contracts, this type of agreement was always concluded at the very beginning of the marriage. It is evident that ancient marriage contracts were not highly flexible in regulating spousal relations. They adhered to stable structures and allowed little space for personalization. The example above illustrates the most common models for defining marital relations, and the key elements included identification of the parties. And this is different in all three contracts. For example, in Egyptian contracts, they identify themselves with their look. If they have something significant on their face or on their body, in order to be recognized. The Romans didn't write any description of their look because they had the three names. The Greeks, the three names and the seven witnesses, of course. The Greeks usually had other people with them, witnesses, and Kyrios for the woman, Kyrios as a legal representative. So rarely they describe themselves in the documents. What is other thing, element included here? Confirmation that the marriage had been concluded, the bride had been given to the groom, with the exception of the last type, singra fetro fitidus. Acknowledgement of the dowry delivery, an inventory of the dowry, stipulations regarding the husband's conduct, stipulations regarding the wife's conduct, confirmation of monogamy, and provisions for dowry restitution in the event of divorce. Regarding the dowry, the husband was not permitted, as I said, to dissipate, to alienate this type of property, since he only held it in possession. It was in bonis mariti. And marriage contracts thus aimed above all to protect the wife. She was assured of property even in the event of divorce. While the marriage endured, she was also protected from mistreatment, since she could bring legal action if her husband abused her or expelled her from his home or from the household. The preservation and integrity of the household, the oikos or the familia, emerge as the central concern of these contracts, reflecting its protected status in all periods of Roman history. So ultimately, the marriage contracts from Roman Egypt demonstrate that despite their formulaic structure, women's rights were explicitly acknowledged and safeguarded through the dowry clauses, maintenance provisions, and stipulation against mistreatment or abandonment. These agreements provided women with legal and economic protection within marriage, as well as men, because there are some cases in the Papyri where the man is mistreated by the wife and he is suing the wife. This was not unusual even in antiquity. So both sides can suffer, but both sides are protected by the law within this contract or by the statutes. I think I'm at the end. I don't have in this presentation slide with thank you, but I'm thanking you. Thank you.